Okay, I've seen the affidavit of service. Mr. Alichair, you said you served the Do you have a copy with you?
Yes, I do. This one, sir.
Sorry, we found a copy.
You found your copy. Okay.
Fair enough. Okay. Let's do a bit of housekeeping now. I've received, the panel has received several documents which have come in thick and fast. So I'll start with you, Mr. Chair, so that we check the schedule of discoveries you filed. Okay? Including the papers. Okay. With the complaint.
Complaint filed on 9th June. I've got the complaint's reply filed on 13th of June to the 1st, 6th, 7th, 13th, 14th, and 15th respondents.
Slowly, Mr. Chair. See, you have the complaint filed on 9th of June.
Yeah, and then I'm going to reply
Yes.
to the
No,
first.
I want you to address what you have filed.
What I have?
You have filed.
Yes, that's what I'm telling you.
Okay.
My complainant's reply to the 1st, 6th, 7th, 13th, 14th, and 15th responses to the complaint.
Yes.
I've got complainants rejoined the submissions filed electronically last night, physically today. Plus the 2 affidavits of service.
All right. For the respondents, who goes first?
On the agenda for the 8th, 11, and 12.
Yes.
On the part, there is a notice of appointment for 8th and 12th respondent, accompanied by replying affidavit separately filed.
For the 8th and 12th.
8th and 12th at the beginning. There is a replying affidavit by the 8th respondent, filed separately. Another replying affidavit filed by the 12th respondent. Upon leaving the station last time, I was also instructed to come on record for the 11th respondent. So I filed a notice of appointment and a replying affidavit for the party. Then, first out your directions, we filed our submissions and accompanying list of authorities. That's all.
Who's next?
Nanda,
Yes, Mr. Nanda.
we filed memorandum of appearance on behalf of 5th and 9th respondents. It's dated the 13th of June, 2022. We also filed a replying
Dated the 13th of June.
Yes, 13th of June. We also filed a replying affidavit on behalf of the 5th and the 9th respondents, sworn on the 13th of June. We filed memorandum of appearance on behalf of the second and third respondents, dated 14th of June 2022. We're applying affidavit.
Dated?
14th of June. Applying affidavit on behalf of
Oh,
the
you're on
second and
record
third.
for the second and third.
Second and third.
We have really struggled with that. Thank you for that.
Yes, it's one on 14th of June 2022.
It's a single affidavit.
Yes, sworn by the second. We also filed written submissions on behalf of the second, third, fifth, and ninth respondents, dated 14th of June 2022.
Dated?
14th of June. That's yesterday. And on behalf of Mr. Wino.
On behalf of Mr. Wino.
Yes, Mr. Wino.
For the
fourth respondent.
Wino appears for.
For the fourth respondent.
Okay.
He filed notice of appointment.
Yes.
Yesterday.
Mm-hmm.
Sorry, on 13th. June, 13th of June.
Yes.
And he also filed a flying affidavit.
Yes.
Sworn on the 13th. I should be all of that.
All right. That's it. You did not file submission?
No, he did not file submissions.
All right. That's it. In as far as the documentary issues are concerned, now I need a confirmation. You have exchanged all these documents. Yeah. Does anyone have an issue with the documentation? We will confirm that you have served upon each other these documents.
Confirm.
Perhaps before we proceed, it has just been whispered to me that my learned colleague Nangi has been denied access. If I can volunteer to go and fetch him so
He's
that he can
cancelled.
also address you.
Yes, please.
Yes.
Yeah, so that I give direction to this.
Very well.
And please allow the registry to get in touch with any of you in case any of the documents you have stated are difficult to trace. Okay? All right?
We've also emailed them,
Yes, yes.
so they should be in the system.
This is a matter of caution.
That's fine.
Wakili amekataza kuingia koti.
Yeah, alikuwa amezuiliwa hapo kwetu.
Hakuna askari hapa?
We tried to pay the person in charge. Yes.
Afisa, Why don't you go and assist this Wakili to access court? He's holding the proceedings of the court, please. Yeah? You need someone to assist you. Martin, go with him. Kama huyo client yake, ni sawa. For the other matters which were listed for hearing this afternoon, please be patient. I can see CRO here and all the other parties. Just be a bit patient. We'll hear all of you. Okay?
My sincere apologies for being late.
Alikuwa amefungia wewe. You okay now? Are you okay now?
Yes, I'm okay now.
You are in a position to proceed.
Yes, we can proceed.
Okay.
Your Honor, if I may say something, maybe if you can kindly ask him to list out his documents, because he wasn't in at the time for listing other documents.
Mr. Nanda, you're holding brief from Mr. Win. It's not Mr. Nyangi. Mr. Midega who told us that he had been locked up.
There were some issues with that.
Okay. No worries. Mr. Nyangi?
Yes, Chair.
We were taking an inventory of what parties. On behalf of your client, what have you filed?
I indicated to the court the other time that I'll be relying on my response, which is akin to submissions.
Nyangi, you appear for
for the 1st,
Yes.
6th,
Mhm.
7th,
Yes.
10th, 13th,
Yes.
14th, and 15th respondents.
Okay. You say you rely on
My response, which is akin to submissions, I'll just highlight a few areas.
dated when?
They are received on the 13th.
Okay. Very good. Okay. That being the case, now, Council, as we agreed yesterday, okay? I'll give each of you. You agree 3 minutes?
Yes, that's the correct position.
You said 3 minutes?
I said 3 minutes
It is
for each to state his respective client's case. You know, Mr. Lucherio, the complainant, so I'll give you 3 minutes. Okay?
I mean, 3 minutes.
Yes.
What about a rejoin at the end?
Yes. On issues law only.
That's fine.
Okay? Not facts.
That's fine.
Proceed.
Thank you very much, Chair. This complaint has 5 main issues, as highlighted in my submissions, and 3 additional ones in my rejoinder. The first one is, did the offices of MCA occupied by the respondents become vacant upon their changing their political party membership status following their entry into the MCA office while in a particular political party membership status, whether they belong to a party or they were independent? That's the first issue. Second issue, were the respondents entitled to continue in occupation of the MCA offices following their changing their political party membership status? Third issue, were the respondents compliant with the moral and ethical requirements of the Constitution and in an Act of Parliament by their continued occupation of the MCA offices following their changing their political party membership status? Fourth issue, is the complaint discriminatory for want of including as fellow respondents all MCAs and all MPs in Kenya who behaved in a manner similar to the respondents? Fifth issue, does the complainant have locus standi in lodging the instant complaint? Sixth issue, is constitutional interpretation the exclusive preserve of the High Court pursuant to Article 165 of the Constitution? Seventh issue, is eligibility for election for the office of MCA only to be determined by Article 193 clause 2 of the Constitution?
Sorry, the last issue?
Is eligibility for election for the office of MCA only to be determined by Article 193 clause 2 of the Constitution? And the last issue is, does the Dispute Resolution Committee of the IEBC possess the jurisdiction to award costs in complaints before it? Because of time limitation, I'll just whiz over those issues. First of all, there are no disputes as to fact in this particular complaint. All the MCAs who are respondents over here either belong to a political party and resigned the membership of the political party in which they were sponsored and became independent candidates, or in the case of one, joined the MCA office as an independent and later joined a political party and later again became an independent. So they've all changed this. There is no dispute as to that particular fact. The issue is, were they entitled to remain in office following their own free will resignation from the sponsoring political parties? They say they are entitled to remain in office. Article 194 of the Constitution, clause 1E, says that if a member changes their political party membership status, either from being a member of a political party to become something else, or elected as an independent and becomes a member of a political party, the MCA office automatically becomes vacant. Just like in the case of death, the office becomes vacant. In the case of written resignation addressed to the Speaker of the Assembly, the office becomes vacant. In the case of missing 8 sittings of the Assembly without good reason, the office becomes vacant. In the case of the end of the term of office for MCAs, at the date of the next general elections, automatically the office becomes vacant. What they're trying to argue is that in their case, the office doesn't automatically become vacant, but you must first of all get the speaker to declare the vacancies, or there's some provisions in subsidiary law, such as the Elections Act, Section 43, Clause 5 and 6, which deals with resignation 6 months to the election, or an exemption provided in Article 193 2A, equivalent to Section 25A 2A of the Elections Act, which says other state officers are not allowed to vie for MCA office except MCAs. That's what they're trying to rely on. But nobody in all the submissions I've seen has addressed the issue of Article 194(1), the automatic vacancy on the event or the happenstance of particular facts. They haven't addressed that. Basically what they're trying to tell us, if somebody dies in office, that office remains occupied by a dead person. And that is basically not correct. So that is the main issue. I'm basically saying those offices became vacant. If the offices became vacant, the MCAs should have physically vacated those offices. They should not have remained in office receiving salaries and remuneration at taxpayers' expense. I'm saying they were falsely representing themselves, even as they still are before you as MCAs, when the Constitution clearly says they're no longer MCAs. They're exercising authority as MCAs, yet Article 2, Clause 2 of the Constitution prohibits any person from claiming or exercising any authority except under the Constitution. They all took oaths of offices to respect, uphold, and defend this Constitution when they entered office, which is part of Article 3, Clause 1 and Article 74, and they're blatantly flouting it and trying to clutter straws in an effort to remain in office and illegally obtain assets and remuneration from the people of Kenya. So these are the moral and ethical requirements within the Constitution that they have not complied with. I've not even gone to legislation. If I go to legislation, the Leadership and Integrity Act, on which the self-declaration form is based, submitted to the EACC and also to the IEBC, there's some very specific questions which requires very honest answers. To get the clearance from the IEBC, normally you have to answer in a particular manner. If you say, I'm guilty of this, you're asked to give reasons. Can you explain why you haven't done it? Most people just say, no, I don't have any problems, and they get their clearance, which is basically pretty much what was done. So if anybody was wondering why I wanted, say, somebody like the ORPP to be here, in case anybody was disputing the fact they changed parties, that was the reason why the ORPP. And in case anybody was saying that they were no longer MCAs, that's why I wanted the County Assembly of Migori County Assembly. But there's no issues of fact, so we don't actually need them. So the issue here is that they have not complied. They all swore Form 19, the statutory declaration, that have complied with all the requirements, have not falsely represented information to the public, and the like. Yet, if we look at the constitutional standard, that statutory declaration is a false declaration, and by that false declaration contravenes the Leadership and Integrity Act and also the Oaths and Statutory Act. So, in essence, I'm saying they have not passed the test in Article 193(2), Article 193(1)(b), which talks of to be eligible to for election as an MCA, you must satisfy the educational, moral, and ethical requirements contained in the Constitution or in an Act of Parliament. Now, I know my colleagues are going to try and argue over here, trying to rely on Article 193, Clause 2. But right now, you mentioned one case is coming up, the Sakaja case, dealing with educational requirements. Educational requirements, you either have it or you do not have it. There is no issue that you can appeal to the High Court, to the Court of Appeal, or the Supreme Court. It is not subject to Clause 2. The matters in Clause 2 of Article 193 are the ones which are given the saving in Clause 3. But the ones in Clause 1 are not subject to the saving in Clause 3. And therefore, if you don't have a university degree and you're applying for an executive position, IEBC can simply bar you. And there is nothing like needing a court order or a decision from the Supreme Court on that one. So therefore, with moral and ethical requirements, as long as they haven't complied with the constitutional standard, they're out. And that is best understood.
One more minute, Mr. Lucha.
Thank you. Let me try and summarize other issues. The other issue they say is that the complaint is discriminatory because I've only brought a complaint against 15 MCAs from Migori County. I haven't brought a complaint against even some of the people who are in this particular court of ours, like say the Murkomens or the Kanatas and the like. They say, for it to be valid, I should see all the MCAs and all the MPs who likewise left the political parties. Essentially, what they're telling us to do, if somebody has stolen somewhere, you cannot issue proceedings against that particular thief unless you bring all thieves in the same action at the same time, then and only then can you sue, which is an absurd argument. Essentially, what we're saying, there's no discrimination. As long as whoever is brought before this court is given a fair hearing, then they're treated equally. That is all we're saying. So there's no discrimination here on that particular ground. The other issue on local standing, they're saying that I have not demonstrated that I am a registered voter in East Kamagambo ward of Migori County. My affidavit says that not only am I a registered voter, I am also a candidate. There is no way IEBC could have declared me as a candidate if I was not a registered voter. So that affidavit is a demonstration of that particular point. The other issue of whether the constitutional interpretation is exclusive preserve of the High Court under Article 165, that is a faulty argument. Otherwise, you would not even be sitting here hearing matters of the Constitution. Article 10 says that any person who, any state organ, any state body, any person, any public official who interprets or applies the Constitution. Article 10 shows that the constitutional interpretation is not the exclusive preserve of only the High Court. Any other person or state organ or state agency does have jurisdiction to interpret and apply the Constitution. The issue of whether the eligibility of the MCAs to be
30 seconds.
determined only by Article 193, Clause 2 of the Constitution, I think I've referred to that already. That is an erroneous issue. Moral and ethical requirements and education requirements are not subject to Article 193, Clause 2. If you have the correct education qualifications, but you don't comply with Clause 2, then you can be disqualified. But if you don't have the education qualifications or the moral and ethical qualifications, then you don't even need to go into Clause 2. So that issue. You know, the issue of costs, what I'm arguing is that the Elections Act does not give the DRC the power to award costs, and I'm very happy that in all the decisions I've had this afternoon, you're basically saying no orders to costs. That is the correct legal position. Thank you.
Thank you, Mr. Chair. Who goes next?
Can start.
In the order of respondents?
For the first respondent.
Please, 3 minutes.
3 minutes. Chair and the honorable panel, based on the time limitation, I can see my colleagues had submitted on the issue of jurisdiction,
Yes.
of constitutionalism, and let them handle that matter. I'll only handle 2 points before this tribunal. The first one being that this complaint is discriminatory, as has been pointed out by the complainant. First of all, honorable panel, Migori County Assembly has 57 elected MCAs. Of the 57 elected MCAs, the complainant has only chosen 15 particular MCAs to bring this complaint against. From my response on record, I have listed other honorable MCAs who are faced with the same predicament from Migori County Assembly. The first one being Honorable Florence Abich Oile, a nominated MCA who was in ODM in 2017 but has migrated to be an independent candidate.
Are they those individuals naming party to this proceedings?
Yes, I've listed them, the names and the parties in my submissions. Yes, there are
Those are named parties in the proceedings before us.
They are not parties, but I'm bringing the element of discrimination. Because he has chosen only a few MCAs who have gone from one party to independent candidates and left out others from Migori County Assembly.
It's in your...
It is in my submissions.
All right.
There are 1, 2, 3, 4, 5,
Let's move on.
6, 7, 8.
Move on, move on.
Yes. Secondly, if this petition is allowed, and still based on the issue of discrimination, there are candidates from Kisii County, Migori County, Mandera, Nairobi, all over Kenya. What will happen if this honorable tribunal committee strikes out the 15 MCAs and leaves there thousands and hundreds of MCAs, MPs, senators, including the honorable deputy president, when they vie and only these 15 MCAs are prevented? This will amount to nothing short of discrimination, honorable panel.
Okay.
Thirdly, on my last issue, the honorable complainant has just admitted that he's an aspiring candidate for East Kamagambo Ward MCA. The first complainant, the first respondent in this complaint is the current sitting MCA of East Kamagambo Ward. The complainant is basically settling political scores and gaining political mileage by going after the sitting MCA him himself being an aspiring MCA. There is a conflict of interest. He's an aspiring candidate. He's not an independent person who has no interest in the seat before you. Lastly, the complainant, having said that he is a Kenyan citizen, he could have brought this action against all other people from Wajir, Mombasa. Nothing prevents him. He only chooses a few people from Migori County whom I believe he has some bias or some interest, political interest against. Because as a Kenyan citizen, he could have even sued the deputy president for leaving office.
You are repeating yourself.
Yes.
Make better use of your time.
Honorable panel. I'll rest my submissions. I believe my colleagues will address the other issues.
Thank
This
you.
was the term limitation.
Who's next?
Council, God bless you. Your Honor. If you read the complaint before you, you will note three things. Number one, the same suffers from misjoinder. Number two, it is a 32-page complaint without any facts or annexures that accompanies it. And number three, there are various misinterpretations of various statutes and the Constitution. On the first issue of misjoinder, no relevant arrow in all those words is a party before you, who is a necessary party to come and defend his position in nomination. Number two, on the issue of facts, there is ground for moral and ethical requirements that in our humble view are factual considerations that must accompany some evidence. Lastly, and this is the crux of the complaint suffers from misinterpretation of the Elections Act and the Constitution. And permit me to point out that what animated or informed this complaint was that my clients who are sitting members of the County Assembly resigned from ODM to defend their seats as independent candidates. And there is emphasis that that was for purposes of general election. We humbly submit that these are persons who are in the category of protected state officers, pursuant to sections 25(2)(a) and 43(6)(g) of the Elections Act, who are not supposed to vacate their offices for purposes of a re-election. We get strength from the decision of the High Court, which we have furnished to the Tribunal, that is Kennedy, Rungu, Ngodi, and another, versus Mary Waidera and Njoroge. The material part is at page 21 of the decision at paragraph 8.
Cite the decision again.
Kennedy, Irungu, Ngondi, and another versus Mary Waidera and Njoroge, and 11 others, is a 2021 decision of the High Court by Justice Mrima. At page 21, paragraph 8, actually the disposition part of it, the good judge says that state officer and any other public officer other than a sitting president, member of parliament, governor, or a member of county assembly who intends to vie for any position in the next general election, subject to any law, must resign within 14 days of the issuance of the notice of the general election. In essence, the judge is saying that these persons are not allowed to vacate the offices if they are defending their position. Let me conclude by saying that there are two good reasons for that, which is worth noting. Number one, and you will realize in that decision, if you retire to make your ruling, is that for one reason, if that will be the case, then it will necessitate a by-election. Number two, for continuity of governance and of services, in the current dispensation, the term of parliament is defined. And even the president does not have jurisdiction or authority to prorogue parliament. So they can be recalled anytime to pass any legislation that they want. The complainant who has misconstrued the law before you wants that the moment my clients resign from ODM to vie as independent candidates, that they were to vacate their offices. That is a misinterpretation of the law. Lastly, there is a unique case on the issue of the 11th respondent, that is Alex Jaoko Akugo. You will note that this person in his affidavit has said that he is not defending his position. He has not been nominated. He is not suited to be before this committee. The complainant is challenging a nomination which is not there. In a nutshell, we do
30 seconds.
we do conclude by saying that the complaint has not met the threshold and the same ought to be dismissed with cost. And of course, just allow me to point out that number one, these are persons who have traveled all the way from Migori. From Sunday to today is Wednesday, they have expended. And then lastly, their campaigns have been interrupted by this most frivolous complaint. I thank you.
Thank you, Mr. Madiga. Who's next?
I'll go next, Honorable Chair.
Yes, Nanda.
Honorable Chair.
3 minutes.
Thank you. The question before you that is being raised by the complainant without disclosing expressly is a question on lawfulness or otherwise of holding office by the 15 members of County Assembly. Does the PLC have the jurisdiction to determine that? We submit it does not. Under Article 165(3) of the Constitution, the interpretation of the Constitution is bestowed mandatorily on the High Court. This tribunal, therefore, lacks the requisite jurisdiction to determine the complaint before it. The complainant has made a vehement before this tribunal on account of answers to statutory questions, or rather on making declarations, statutory declarations. Those are not before the Honorable Tribunal. No evidence has been presented. Section 107 of the Evidence Act requires anyone who alleges the existence of any facts to prove those facts. The complainant has terribly failed to prove the facts he wants the tribunal to act.
Okay.
Not even one declaration has been attached to the complaint. Honorable Chair, the complainant is asking this tribunal to find the respondents criminally liable under Section 11 of the Oaths and Statutory Declaration Act. Does this tribunal have the powers? We submit it does not. Not even a charge has been leveled against any of the respondents. There's no finding by any court of law on the guilt or otherwise of the complainants. How then would the tribunal make a finding that they are not eligible for election on account of criminal liability when there's no decision on their verdict, or rather on their guilt? Honorable Chair, the complainant is asking you to disqualify the 15 respondents from running elections. Disqualification of any candidate is expressly provided under Article 193 2G, 2 of the Constitution. And in this respect, I would address you on Article 193 2G. It only disqualifies a candidate when that candidate has been found to have violated Chapter 6 of the Constitution or any law. None of these respondents has been found to have violated any provision of the Constitution, any provision of any law. In fact, all of them have never faced any legal proceedings, save for this one. The complainant, Honorable Chair, I would ask you to extend leniency to me because I'm also calling brief for Mr. Owino.
No, we'll start Mr. Owino's time. Don't worry about Mr.
Oh, very well.
Owino.
Thank you.
Plead your case.
Thank you. Honorable Chair.
You have 1 minute.
Thank you. None of the complainants hearing has been before any court of law for any offense. and therefore they meet all the requirements. At the time of clearance, there was no impediment against any of them, and that is why they were cleared. The second and the third respondents are not sitting MCAs. Which office is the complainant asking them to vacate? They only elected in 2013, and they lost elections in 2017. They're not holding any office. So if you say they're acquiring public property unlawfully, and yet they're not holding any public office, you need to prove.
Okay.
On behalf of the second, third, fifth, and ninth respondents, I rest. Allow me to proceed on behalf of Mr. Owen.
Yes. Is this case unique from what you've just presented on behalf of the second?
Just on one aspect, and that is
Yes.
what I want to address.
Just address that one aspect, then associate yourself with your previous submissions.
I thank you. Mr. Wino has not filed submissions. With his reason, his client, the fourth respondent, does not hold any public office. His client has not violated any provision, or rather any averment as alleged in the complaint. This complaint does not therefore apply to him. And we pray that the same is dismissed with costs. Thank you, Honorable Chair.
Mr. Chair,
I'll quickly whiz through the issues I've raised.
a rejoinder hearing
Yes, just
strictly on issues legal.
yes, issues I've raised. There's an issue here of whether there's a conflict of interest. I fail to see how that arises, because when you look at the rules for procedure on settlement of disputes regulations, either a registered voter can bring a matter before you, or any person can bring a matter before you. So even in the category of any person, I am a person, so therefore I do have locus standi to bring the matter before you. On the issue of misjoinder no arrows, I have no issues with the arrows. The arrows are relying on the declarations that were made before them, and as far as the information that was given to them, they did everything in the manner they were supposed to do so, so I've got no issues with the arrows. On issues of no facts or annexures having been placed before you, evidence, etc., 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 I have made references to Kenyan Gazette notices, and under sections 59 and 60, these are matters of which you should take judicial notice of. I was relying on publicly available information, not private information. So anybody can access all this information. So I don't need to produce anything else. And on the other hand, none of them have contested to any of the issues that I've raised. There is no dispute as to facts. So all the facts are basically agreed, so we can only argue about the law. On the authority that was cited before you by Justice Mrima, I was being read by my colleague over here, there was a phrase that says, subject to any law. Justice Mrima qualified his comments as subject to any law. In this case, we've got Article 194, 1, which talks of vacation of the office of the NCA, which is superior even to the opinion of anybody else, even a judicial office. There is an issue that I'm targeting ODM, former ODM members. First of all, I should declare here that I'm not a member of ODM. I belong to the Justice and Freedom Party, and we have no cooperation or any association with ODM, and therefore I'm not fighting ODM's corner. I'm just taking things as I found them. There is an issue of why leave out the others. Well, I must say that that was an oversight. If I hadn't oversight on the particular matter, I would have added them all in. So that was just an oversight. But even then, sometimes you don't catch all thieves at once. You bring them before the court one at a time, as you catch them. There's the issue of the 11th respondent. The 11th respondent has, until the presentation of his papers to the RO, been participating in the elections, ongoing elections process. Elections are a process. He took part in the ODM nominations. He resigned ODM.
Those are issues of fact.
Okay, fine.
I know they will then cause
okay,
relevant.
I've addressed that in my reply, so I'll skip that.
So let's leave that out.
Okay.
Any issue of law, and now you have
Jurisdiction. They said you don't have jurisdiction. Now, saying again, trying to cite this is a matter only for the High Court, that references to criminal law that are referred to over here are basically you have no jurisdiction whatsoever. Your role is under Article 193, Clause 1, whereby you're checking eligibility under educational, moral, and ethical requirements. If somebody, as is clearly seen, has violated one particular law, be it criminal law, administrative law, any other law, constitutional law, you have to take that information in assessing the moral and ethical requirement compliance of the particular candidate. I'm not come here for you to jail anybody, no. Just to assess, have these people complied with the moral and ethical requirements? And for that, you have jurisdiction. The other issues, second, third, and fourth respondents who are not currently serving as MCAs. They served as MCAs between 2013 and 2017, and in the equivalent period before the general election, they behaved in a similar manner. So with respect to the second, third, and fourth respondents, it is their behavior between the time they left their sponsoring political parties and the time they took part in the general elections. They were basically parading themselves as MCAs, though under the Constitution, the seats were vacant. Since that was their behavior then, the behavior then is applicable to the behavior of the current sitting MCAs. They're also not compliant with the moral and ethical requirements under the Constitution. I rest my case, TRC.
The committee will render its decision on this complaint on the 18th of June 2022 at 2:30 p.m. Thank you, Council, for your cooperation with the committee and keeping time. There's a mention that the panel had set for 4 p.m. Council, in court.
Basic intelligence of the committee. My matters are listed at 2:30, and I wish to rely on the documents as such. I don't know if you can call them out before, because I have other engagements in another matter, and the time is quite. You can be kind enough to mention. Yes. Like in 228, I wish to rely on documents as filed.
Just hold on a minute. No, I don't have your file.
Very well.
Your case number?
228 and 224. No? 228 and 224 of 20.
you say in both matters you rely on what you're filing.
Yes, the complaint and the supporting evidence. Same for 22, maybe we could just start with 228.
Yes.
Because in 228 all the parties they were agreed. 224. No, 228 all the parties are wishing to rely on the documents. So we can take it out.
Good afternoon, Mr. Chair. In 228,
No, 228.
let's listen. In 228, I have received instructions at around 2 p.m. today to come on record on behalf of the first respondent. The first respondent was served at 10:47 in the night.
Who are you?
My name is Odera. My name is Green Odera.
So you're coming on record for Billy Odiam.
Yes,
He's the second respondent.
second respondent, my apologies.
So now, Mr. Ayeko,
Yes,
you filed the
return of service indicating the time was served at about 1:47.
okay, and that now brings Mr. Odera to court.
Yes,
Isn't it?
yes.
The appeals. So Mr. Odera, tell me, are you ready to proceed?
No, with regards to 228, that is this current matter, I'm not ready to proceed because I have received instructions at around 2 today. I'm in the process of collecting documentation and filing a response on behalf of the second respondent. I just pray that the matter be adjourned so that I file my documentation and proceed with the same tomorrow in the morning or any other time that is convenient for the committee.
Mr. Ayeko.
Honorable Chair, if I may, my name is Wakoko. I'm present on account of directions of this committee to provide information to the committee on behalf of the Office of the Registered Political Parties. Ceding to the direction of this committee, we have filed a replying affidavit, which is with the committee, and we have served the same council and in the matter.
The affidavit of Joy Nyang. Joy Nyang.
Yes, under the hand of Jay Yango, Chairman.
All right. Now, Mr. Odera.
Yes.
We don't have a lot of time. Okay? So, what we do, file and serve your response. Okay? The claim.
Yes.
By 8 o'clock in the morning.
Guided, Mr. Chair.
Mr. Ayeko, Mr. Wakoko, we shall hear this matter tomorrow at 9 o'clock.
Okay, Mr. Chair.
Can we have it then in the afternoon? 9 is a bit, tomorrow is not a good day. Or better still, can we then Your Honor, maybe perhaps, can we then file whatever we want to file, including submissions, and get a ruling? Because in the morning will not be convenient for me to come. I have another matter which was scheduled previously.
Are you all agreed that this matter can be settled by written submission?
You know, I can settle for written submissions now that
Very well.
I'm the one who has requested.
Mr. Wakoko? Are you okay with that?
That's agreeable, Chair. And Chair, if I may, I will not be filing any further documents. I'll just confine myself to the replying affidavit, which is already on record.
So, all right. By consent of the parties, the second respondent shall have leave to file a replying affidavit. 2, the complainant file and serve written submissions limited to 3 pages, font and spacing 12.5, okay, with soft copies lodged at the committee's address, email address. You have been here before?
Yes.
You shall get the email address. Okay. And the hard copies of the written submissions filed with the registry at 8 a.m. The respondent shall file written submissions in the manner and format directed above by 12 noon on the 16th of June 2022. All right? The decision on this matter shall be delivered on the 18th of June 2022 at 2:30 p.m. Right? Get to you.
Most obliged.
Okay?
Most obliged, General.
Right.
And the next one, 224.
You still have another. Do these 2 matters which were released?
Yes, yes, yes.
So, Mr. Odera, are you appearing in that one?
Yes.
Mr. Okoko, you are not in this one. So what's the story here, Mr. Ayeko?
For me, I would propose we take a similar approach in that one.
Aro Tasipu? The present. Okay. ODM?
They were served and there is return of service.
Zakayo Okuma Ongondo?
Your Honor, I am on record for the first respondent, Zakayo Okuma Omondo. I am here together with Mr. Kenyan.
Odera and?
Chino.
For the first respondent. Ayeko, you continue on record.
Yes, for the complainant.
Aro, you're present?
Yes.
I've seen you filed a replying affidavit dated the 7th of June. Okay, now. As a matter of housekeeping, Mr. Odera,
Yes.
you've been served with a complaint.
Your Honor, I've been served with the complaint.
You have seen the returning officer's affidavit.
I have not seen the returning officer's affidavit.
Okay. This matter was due for hearing. Are you, Mr. Ayeko, asking the court, or rather the tribunal, to allow you to settle it by way of written submission so that we can retire to write our decision? And I believe, if I'm not wrong, these were the directions given yesterday.
Yes, yes.
Have you filed?
I wish to rely on my complaint and the supporting affidavit. But if they are hesitant in written submission, we can as well do. I was just pressed
you've not
for time.
filed?
That's
Other ones?
what made me to seek the indulgence of the panel. Because I have another matter and I'm not sure even if he has started the meeting.
The supporting affidavit you
Yes.
talk about.
With the annexures.
Yes, I've seen it.
Yes.
Now, Ms. Odera,
Yes, sir.
move quickly. I'm going to grant you leave.
No, Your Honor, in this one I have responded. I
You
have
have?
filed my response. On June 24, I have filed my response.
When did you file? Okay. All right. I've received it. Ms. Ode,
Yes.
this file a notice of appointment supporting affidavit.
A replying affidavit. Mr. Chair, you might need to read the whole sentence. It's a replying affidavit to the complaint and the supporting affidavit in support of the complaint.
Okay. Zungu yangu ilikuishia man. So,
That's my worry. My worry is I'm seeing what is being supplied into court is quite bulky, and this is what I've been served. So,
it's just that mine is bound. Don't be
but
scared.
in terms of size, I don't know whether my eyesight has a bit of a problem. Perhaps you can pass
Mr.
it
Chair,
to
there is
them.
an explanation, and I actually gave that explanation to Mr. Yep, that the only thing that makes the court document bulky is that I have annexed the document that he served me with. I have raised issue with the complaint as served upon myself that there are certain mistakes that he made. So the document that he served me is what is there that is not in the copy that he has. The court can confirm.
So I think to be fair and for matters of procedure, you serve your fellow advocate documents as filed. So
Do you have an
perhaps I
extra
would
copy of
request
this?
if I can be
Ms.
given.
Odera,
Yes, sir.
That's
Yes,
okay,
sir.
that's satisfying. That's
do
okay.
you want my bound copy?
No, that's okay. You can just compare the
No,
picture.
no, seriously,
This
on a
other
serious
one
note.
is 2,
On a
3
serious note,
pages.
we need to move, huh?
Very well.
The day is quickly running. So, Ms. Odera,
Yes.
not to lead you to any conclusion, do you wish to rely on what we file?
Your Honor, I wish to rely on the replying affidavit, but I wish also to highlight some of my some of our strongest issues with regards to the complaint as filed, so that if counsel is ready, maybe we can highlight this complaint.
Can we do this? Mr. Eko wants to take off. I will give you leave to file written submissions. All right? Okay? Highlighting the strongest points of your document. All right? Do this by tomorrow 9.
By tomorrow?
9 o'clock. Because we have the affidavit, isn't it? Arrow, you shall be adopting your replying affidavit as evidence in this matter. Okay? All right? Okay. So, I think, Mr. Odera, with that latitude, we can quickly give directions as to determination of the complaint.
Guided, Mr.
Thank you.
DRC number 192, Phineas Mutharima versus Arrow Gembe Central. Phineas Mutharima.
As the other parties organized. So Mr. Eko, Mr. Odera, and Arrow. Mr. Odera, you shall have leave to file your written submissions both in hard and soft copies, limited to 3 pages. The soft copies of the submission shall be in Word format, okay, filed with the tribunal, okay, and sent to the email address that the secretary shall give you. Okay, make sure you leave with the email address. You can ask Mr. Yeko to make it. The returning officer as affidavit has been asserted as the evidence in this matter. So you are discharged. Okay. Decision on this complaint shall be delivered on the 17th of June 2022 at 2:30.
You say 17?
17 at 2:30. Those who are here for the matter that was referred from panel 3, specifically the Sakaja matters, we are fighting against time to clear with the cause list for this panel. I'm looking at the time, and I think we shall need as a panel at least another 30 to 45 minutes to clear. So can we all convene here at 6 o'clock? All right? Hata mkipiga kelele, let me tell you, we are trying as much as possible to accommodate all of you. All right?
Mr. Chair, just allow me to say one thing.
Just a minute, please. I am talking. All right? I want to hear all of you. All right? But in my panel, there are matters which have been here since morning, and I need to dispose of them. All right? Please, can you come back at 6?
On behalf of those in the Sakaja matter, we are most obliged. We'll come at 6.
Please, let's come back at 6. Na tuache kelele tafadhali, sisi wote wa Kenya. Siasa isitugawanyishe. So please come back at 6. All right? Aya, call those matters.
DRC number 52, Jonathan Gikabu versus Sierra Meru.
I'm coming from here, and I'm number 56 in the...
What does it matter?
My matter was between me and Arrow.
What is your name?
Number 37 has been cleared, so I like to know my verdict because I'm now...
You'll see the registry. You'll go to the registry, okay? You'll get a ruling from the registry on Friday.
Just allow me...
You must have come late.
We have already read your ruling.
Actually, I've been here since Friday. Secondly, I've come here as early as possible, and I've heard number 37 being mentioned, the verdict, and I'd like to know my verdict because I've been stranded all along the road. I'm just
What's your matter?
Because I'm missing only one
Your name.
Kenyan Mutai.
Which constituency?
Sotik.
Sotik. It's already read. We have read it out. You are not there when we read it out.
Then here, because I have no problem, because I'm waiting for a leave that should be leave at 5:30 p.m. So I'm running with the time. Now that I support my left.
Unasema jina gani?
Kenyan Mutai.
Aya. Ilikuwa imesomwa, but just for your information, these were the orders upon analyzing the relevant statutory requirements and the applicable regulations, and upon due consideration of all material before us. Upon considering the arguments advanced by both sides, we find that the complainant has not satisfied the threshold for this committee to grant the order sought. Accordingly, this complaint is dismissed with no order as to costs. Alright? So, which matter are we dealing with? CRO. Which matter is this?
This one of Jonathan Kapu.
Jonathan Gikapu?
Ona yeye akupatia ruling yako. You cannot read again. See the secretary to get your ruling.
Okay.
I'm just presenting Jalagat Simbaringo than I did.
No. You know, we can't keep going round and round in circles. Please, you wait until the end of the course list, then we'll hear you. Now we have to move.
I have one request, kindly. I'm not feeling well. Even I told the CRO, that's why I never told this thing.
I think your matter was dismissed. Okay. Why don't you see the registry? They will guide you accordingly. Assist them to the orders of the tribunal. Wapi nani? Jonathan Gikabu?
Your Honor, I'm here.
Oh, you're present.
Yeah.
Okay.
Around.
Present, Your Honor. Haya, endelee. Jonathan, you have 5 minutes, please.
Yes. Thank you, Honor. So, first and foremost, as I begin, I'm happy I had your ruling on...
Silence in court, please.
Okay. May I continue?
Yes.
I had your ruling, and one of the articles of the order, Chapter 7, Article 83.3, which means the process that we've been undergoing is there to enable us, not deny us, particularly independent candidates. And just to be candid with the panel, the reason we are here, the reason I'm undergoing this process.
You will find your affidavit, Jonathan.
Yes, I said I am relying on my complaint and demand letter.
You do not file an affidavit?
No.
You have to be sworn.
I, Jonathan Gikapu, and solemnly swear that all I shall state in this proceedings shall be the truth and nothing but the truth.
Now, your complaint, huh? I've seen it. It's a question of number of supporters.
Yes.
Okay? Just to move it along quickly, so that we don't waste a lot of time. You say you had met the minimum requirement on supporters.
Yes.
Isn't it? Yes. You are vying for which position? Senate. So how many signatures and copies of IDs were you to have?
I provided 3,381 signatures both in the phone and soft copy.
You provided 3,381
in 3 separate forms.
Okay.
Yeah. The first batch was 2,195, the second one was 1,185.
This is including the copies of ID? Eh?
Yes.
Okay. All right. So after you provided this,
yes.
You can see from 19 here.
Yes.
Indicators that only 1,458 signatures were verified.